So thank you. Good afternoon, everyone, and thank you for being here. Today we invited Anna Aranguiz and Anne van Lancker, and they will present their expert study on a European minimum income study. So on a study about the feasibility of a European minimum income framework at the EU level. A legally binding one. And I'm very excited that they are here. Anna Aranguiz is a postdoctoral researcher at the University of Tilburg at the EU Horizon 2020 project working yet poor. And Anne van Lancker is a Belgian politician. She was 15 years an MEP for the Social Democratic Party, the Flemish one, and is now a consultant on social policy and is involved in various social organizations, social NGOs. Without much further ado, I would now give the floor to them. They will present their studies, and then we have enough time for a Q&A. Thank you.
Okay. Thanks to Anna, who is helping me to share the presentation, because with my computer it didn't work well. So in fact, the both of us are going to present to you an expert study that we did for EAPN on the possibility of having an EU Framework Directive on minimum income. I will sketch you a bit the social and policy perspective, and Anna will focus more on the legal feasibility, the competences, and the content of such an EU directive. Okay, let's go. Okay, so this is the outline of our presentation. I will only present the context and a bit of the rationale. Why should Europe be involved with minimum income? Is that not more a case for national governments? And then all the rest, putting the framework, the legal competences, the form, the content, and the conclusions will be done by Anna. Next, please. Okay, the context then is the context of poverty in the European Union. In the rich continent that Europe is, we still have more than 20% of people who live in poverty or at risk of poverty. You may know that this indicator is a composite indicator, which means that it adds the people who are living at risk of poverty, and that in its own means that these are people who have as an income less than 60% of median income in their country. You add to that people who live in severely materialized, deprived situations, which means that they cannot afford to pay the rent or keep their home warm. They can't afford to eat meal or proteins. They don't have the means to buy a TV or a washing machine, a car. They can't go on holidays. So these kind of indications. And then you add to that the people who are living in households with very low work intensity, which means that if you add all the work of one family together, you get less than 20% of a full-time job. Okay, next, please. We all know that social transfers, particularly in the Nordic countries and also in Western Europe, are very effective means to bring down the at-risk of poverty rate. Here you see the blue bars is the at-risk of poverty rate before social transfers, except pensions, because pensions in itself, of course, is a form of income. And then you add this is the poverty rate, I mean, before social transfers. And when you do the social transfers, which is social protection, unemployment benefits, invalidity, sickness benefits, but also minimum income, then you see the poverty rate diminish in countries, and some countries are really very successful in achieving this. What we are going to talk about next, please, is only part of this social transfer scheme, which is minimum income. As you know, minimum income or social assistance or whatever you may want to call it exists in every country in the European Union. only recently, because only a few years ago, Greece developed its own scheme and Italy only 2 years ago. And we have a common definition for this. These are the last resort schemes to ensure minimum standards of living for individuals and their families who need it. It's income support. It just gives you a safety net to people who are out of work or who work but earn not enough to be able to live a life in dignity, and who have exhausted, whose entitlements to other benefits have expired. And as I said, these are parts of a more comprehensive rights-based universal social protection scheme, where there's also pensions and unemployment benefits, etc. Next, please. If we judge the quality of minimum income schemes, we have three main criteria. The first is adequacy, and I will tell a bit more about the three, which means, is minimum income enough to live life in decency? The second is coverage. Do we really reach everybody who needs minimum income, or are there groups who fall out of the schemes? And take up, which means that people who have a right to access certain schemes like the minimum income scheme, do they also effectively take up this right? Next slide, please. First criterion is, well, this is hard to read, but I will explain a bit. Are minimum income schemes adequate? The horizontal bar sketches the percentage in which minimum income is expressed in relation to the poverty threshold. And as I said, the poverty threshold is 60% of median income. There you can see, if you look very well, that only the Netherlands and Ireland, for a single person, which is this graph, have more than 100% over the poverty threshold, which means that minimum income in Holland is adequate because it represents 60% of the median income. Then the vertical bar is the reference to what it represents in terms of low wage earners, and we call a low wage is 50% of median wages, and there you see that in all countries minimum income is below the low wage threshold. If you look at the bottom of this graph, if you look very carefully, there you can see that Romania, Bulgaria, Hungary, Lithuania, Slovakia have minimum income schemes who are really poor because they only give people the less than 40% of the poverty threshold. So not 40% of median income, but 40% of the poverty threshold, which is something you really cannot live off. Now the next slide presents another image, because sometimes people ask, why would you express the poverty threshold in terms of median income? What does this represent? Is it really, does it make sense? Is it enough? Is it not too much? Well, you have another way of presenting poverty, which is by filling baskets of goods and services that people need to live in dignity and to participate in society, like housing, having food, personal and healthcare, being able to be mobile, clothing, maintaining social relations. And these are all the colored bars that you see for different countries in Europe. And then the black line is the poverty threshold. And there you see, when you look at the situation in Antwerp or in Helsinki, that the poverty threshold of the 60% is almost equal to reference budgets. When you go to Budapest, you see that what people need according to the baskets is immensely more than is represented by the at risk of poverty threshold. So saying that the at risk of poverty threshold is put too high is simply not true. It's rather the reverse, it's too low. So in fact, you need more than 60% of median income in lots of countries in the world to be able to live a life in dignity. This is what I wanted to say for adequacy. Now we come to coverage in the next slide. Do we really need reach all the people who are in need of minimum income? Now, no. there are many countries in which the eligibility conditions exclude parts of the population. For example, Denmark is a country where where you have age requirements where I think people below 25 cannot access minimum income. You have countries where there's mean testing, which means that they're going to look for all your possessions, even if you are you are an owner of a small house. Well, if this is tested, it means that you don't have the right to access access minimum income. Lots and lots more countries are adding now residence requirements. For example, in the Flemish region, we have a separate scheme. And now it says that you have to be in the country for at least 10 years, of which 5 years uninterruptedly before you can access the scheme, which is very exclusive, of course. And this makes that lots of groups face problems to access minimum income, like migrants or asylum seekers, homeless people, because most of the time they don't have addresses, and you need an address to prove your residence. But also, as I said, young people and other groups who fall between two schemes, like long-term unemployed who lost their right, who have expired their right to unemployment benefits. Another serious problem is non-take-up. Lots of people are not aware that they have the right to ask for minimum income, but you have also many countries where the procedures are so complex and so restrictive. There is so much conditionality. I remember having studied minimum income schemes in some of the countries, like Latvia, I think, or Lithuania, where one of the conditions was also that a social assistant came in your house and to look if you were able to keep your house clean before you could access minimum income, which is something very weird. So non-take-up is a really serious problem, whereas minimum income should ensure universal access, which is non-discriminatory and which does not impose unreasonable conditionality on people's rights. Next, please. Now, nobody wants to keep on living from minimum income. It's a very low income. It does not give you very much satisfaction. So this means that minimum income should also help people to get back into the labor market in quality jobs. So you need to combine it with activation strategies, but in many countries, activation strategies are increasingly punitive. It's like, well, questioning people and not questioning the labor market, because sometimes there are no adequate jobs for people who are on the lower skilled end of the labor market. And what we really need is an integrated approach where you give people adequate minimum income, but you combine that with individual case management, where you lead people to good jobs on the labor market that they can take up, and probably also to accessible essential services to be able to do so, like, for example, public transport or childcare for single mothers, for example, who have a child at home and who have to have it placed in childcare before they can take up a job. So there's a lot of things, of conditions combining with adequate minimum income to be able to speak about qualitatively good minimum income schemes. Next, please. Well, this is, of course, an important question. We all understand that having the right to minimum income that is high enough to live in dignity is a question of human rights for people. It's also a condition to be able to participate again to the labor market. But then the question is, why should Europe get involved? Now, if you look at Europe's history, Europe and the member states have a relatively strong social agenda. You have the Charter of Fundamental Rights. There's a lot of treaty articles, of which Anna will speak in a few minutes. You have the European Pillar of Social Rights, which is a relatively new instrument, which in its Principle 14 says that people should have the right to adequate and accessible minimum income schemes. And these commitments should, of course, be translated into binding social standards and not just be promises somewhere floating in the air. Now, politically, it's important, I think, that Europe, that is so forceful in its action when it comes to the economic strand, also increases its legitimacy with the population by adding a social strand and giving people rights, so that it's not just a big market, but also a market with social rights, which is guaranteeing social rights for its citizens. And we also have a very strong economic position to defend action at EU level. Better incomes for people are likely to improve productivity and boost demand. You can really see that those countries which are, as you can foresee, the Scandinavian countries, have the strongest minimum income and social transfer schemes, who also are the most resilient economies when they are faced with crises. And there's another argument, which is a bit of a negative argument. If you don't combine the economic and monetary union and internal market with social integration, with real active social policies, then it would put pressure on the welfare states, and you would not only have fear for social dumping, but real social tourism, because then you would have competition on the basis of social policies, which is really something that Europe should avoid. And then my last point is, okay, maybe Europe should act, but what would it cost? Well, there are only tentative calculations that show that the cost is very uneven. The total cost of having adequate and accessible minimum income in the whole of Europe is 82 billion euro, but it depends a lot on countries, for which country you would pay more. And it's a bit self-evident that those countries in which the minimum income schemes are already the closest to the at risk of poverty threshold, that it costs less than in those countries who are lagging behind, like Bulgaria, Romania, Latvia, Lithuania, but even Italy. Now, there's another argument I showed you when explaining adequacy, that you really need to ensure that there is a positive hierarchy between minimum income and minimum wages or low wages. Well, if you keep raising minimum income, you run the risk of having minimum incomes that are higher than minimum wages, which does not really create an incentive to take up jobs. So if you have to also give financial incentives at the bottom income distribution for wages, then you would need double of the 82 billion euro to make it all work well. Now, what we see, if you focus on the countries, is that the richer people in poor countries are poorer than poor people in rich countries. That, of course, has a lot to do with the relative richdom and the relative wealth in the different countries. It's not the case that, for example, people in Romania earn as much as people in, let's say, France or the Netherlands would earn, and they also have to spend less. But richer people in poor countries that are poorer than poor people in rich countries is weird, which would mean that if Romania would like to make its minimum income scheme adequate and reasonable to live and to give people a life in dignity, you would be pressed to tax people, to tax the richer people in these poor countries even more, which brings them down the bottom of the social welfare states, and that cannot be done. And that is the reason why there's European aid that is needed, support of structural funds, especially the social fund or the regional fund or the resilience funds that have been recently created. And the good news is, and that is the last sentence I will say, there is research that has been done across Europe that shows that public support for adequate minimum income schemes is very strong, even if that means that the richer countries would be forced or would be invited to pay for the poorer countries to help them construct minimum income schemes that lift people out of poverty. And now I hand over to Anne.
There we are. Sorry, I needed to unmute myself and I lost the screen. Hi, good afternoon, and thank you very much for inviting me. Special thanks to Sophie for reaching out to us. And I will start where Anne stopped and explain a little bit the legal side of this proposal or expert study that we put forward. So as she explained, there are a number of socioeconomic reasons to adopt an instrument on minimum income. But not only that, there is also an existing framework in the EU that could accommodate such a directive. We have a legal framework composed by values, objective, the social objective in particular, linked to fundamental rights, whether in the EU and the Charter or other instruments such as the European Social Charter. And more recently, we also have the European Pillar of Social Rights. Now, this normative framework has translated in a number of policy commitments, most notoriously perhaps on two council recommendations, the Europe 2020 strategy, and more recently in the action plan to implement the pillar, which plans to adopt another recommendation, this time explicitly on minimum income. I think it's next year in the springtime. There is on top of this support by a number of institutions, such as the Parliament, European trade unions, etc. But seeing how recommendations have insufficient, as Anya said, still minimum income are very, in member states, are very low and are not sufficient to combat poverty and social exclusion. The question is whether the EU can do more and can give these minimum income recommendations a harder edge. And this brings me to the question, and what's been very often the elephant in the room, whether the EU has the competences to adopt a directive on minimum income, to adopt the binding instrument on this issue. In very short, I can tell you that what our expert study finds is that it is possible, and our suggestion is to use two different legal bases and to combine the social competences of the Union and the social cohesion competences. Now, let me begin with the social competences. According to Article 4 of the Treaty of Function of the European Union, social policy is a shared competence, meaning that the EU will only act insofar as this is necessary to attain one of the objectives. And it will do so in compliance with the principles of proportionality and subsidiarity. Now, when we look at the specific, excuse me, I hope this doesn't interfere too much. Okay, all right. Can you still hear me? Okay, then I will continue. When we look at the specific social competences, we have the infamous Article 153, which you can see in the right. Now, I don't expect you to go over the entire provision. This is just to give you an idea of how complex this provision is. And because of how complex it is very difficult to formulate instrument on this basis. So in the first paragraph, we have a number of fields, actually quite some fields on social policy where the Union has the competence to act. Now, while these are actually quite ambitious and quite broad, this is undermined by the following paragraphs, which set a number of limitations to these fields. And I will look into the specific fields that could accommodate or not directive on minimum income. So if we look at, if we are thinking about minimum income as a form of fighting poverty, that's the idea of our expert study. The first field that we look into is obviously combating social exclusion. However, this is one of the true fields in Article 153 that does not allow for harmonization. Any measure that the Union takes in this field is limited to measures of coordination. As such, if you're thinking about a directive or about a binding instrument, we cannot use this competence. But there are other competences that do not have this limitation. Some have argued, other researchers, that perhaps the possibility could lie on the field on social security and social protection of workers. And while from a material point of view, it would be possible to see, according to the interpretation of the Court of Justice on what social security and social protection entails, to accommodate an instrument on a minimum income. However, from a personal scope point of view, this is rather limited. Because this field is directed to workers, it inevitably excludes people who are not at work. And as broad of a concept as we can use of worker, this excludes a number of people, probably those who are in bigger need of accessing minimum income systems. On top of that, this field requires unanimity and the special legislative procedure, so it would also be not very feasible, politically speaking, to adopt such an instrument. And this is why we didn't choose to go for this field. Excuse me. But we have field H on measures for integration of people excluded from the labor market. Now, in contrast to the former field, this allows for a much broader scope, but it is still somewhat limited in the sense that insofar as it is directed for people excluded from the labor market, it does not cover those who are included in the labor market. And of course, the definition of this could be broader or narrower, but inevitably it would exclude a number of people. And if we talk about the number of people that are increasingly in a situation of in-work poverty, we saw this also as a limitation, particularly because we try to use a principle enshrined in the European Pillar of Social Rights, which talks about a minimum income at all stages of life. However, this field also allows for qualified majority voting and the ordinary legislative procedure, which could be a lot more feasible to adopt in negotiations. On top of that, there are a number of limitations which apply to all the field of social policy, which are inter alia that the EU cannot regulate fundamental principles of social security. Now, we don't see this as a problem because, as Anne already said, all member states have some sort of minimum income system, and as such, the fundamentals are already there. And this could be adjusted depending on how the instrument is formulated, which I will go to in a minute. Another limitation is also to not significantly alter the financial equilibrium of the social security system, which could be fixed by, first of all, aiming for a gradual implementation of a directive, and second, by supporting this with European funds, as Anna has mentioned, for example, the European Social Fund Plus. All in all, we think that this is a very solid field, which could accommodate a solid instrument, but it would still exclude those who are in the labor market, which is the major limitation. Because of this limitation, we wanted to look into other alternatives outside the social policy competences, and we looked into the cohesion competences. We can find this in Article 175, and our competences that the Union has to adopt measures to strengthen economic, social, and territorial cohesion in the EU. Now, because this is the competence, the goal of any measure adopted under this basis could be to reduce socioeconomic disparities between member states by engaging into upward convergence. This means that if we use this competence, an impact assessment of a directive could inevitably have to demonstrate that a minimum income framework directive would somewhat significantly decrease inequalities between member states. On a positive side, however, there is no limitation on the personal scope of Article 175, which could mean that we could, in fact, go for this at all stages of life minimum income, as it is in Principle 14 of the European Pillar of Social Rights. The major downside of using this competence is that this is not a social competence, so it's a cohesion competence, and there could be potential interpretive challenge before courts, imagine, if there is a conflict between the social part of this directive and perhaps the territorial or cohesion objective. This is why we thought that the best solution for a directive would be to combine Article 153 on integration of people excluded from the labor market and this provision. Now, I won't dwell much into this issue. It's pretty technical, and I think they're mostly lawyers, but there are a number of conditions in order to use two different competences in the Union, but in this case, they are fulfilled. So the conditions are as follows. There cannot be a hierarchy between the two different provisions. There cannot be a separable aim, which in this case could be that the instrument of minimum income aims at improving living conditions for the EU population, which would require, on the one hand, the integration of people excluded from the labor market, and on the other hand, to reduce disparities between the member states. They don't have contradictory procedures. They both require ordinary legislative procedure and the qualified majority voting, so that's not a problem. And there's also not a problem because both require co-legislation. Therefore, there's no institution that is undermined in the process. This is why in our expert study we found that the dual basis approach is possible in the first place, but it's also desirable because on the one hand, it broadens the personal scope, which is much necessary for a minimum income scheme that aims at being universal, as Anne was explaining. And on the other hand, because it avoids any future interpretive problems between social and economic objectives, and it makes very clear that the objective is social in nature. Other question regarding that legal aspect of it is why we aimed for a framework. And this is because we consider that a framework is best suited to leave to the member states the primary responsibility to implement minimum income schemes, and to the EU to set some core standards and methodology for member states to operationalize these methodologies and reach these core standards. A framework also helps comply with the principle of subsidiarity and highlights the idea that there is no one-size-fits-all approach for a minimum income scheme. It also emphasizes the idea that member states remain free and are either encouraged to adopt higher or more stringent standards. Regarding the compliance with the proportionality test, on the one hand, we have the fact that soft law instruments in the past have not been sufficient to reach this, which leads us to believe that more is necessary. And on the other hand, we have a methodology that adapts country to country. So this could be the reference budgets and the AROPE threshold that Anne was talking about before, to make sure that it doesn't go beyond what is necessary. This is also very compliant with the non-regression clause, with the idea that a minimum income directive could not lower the standards that are already set in member states, that is in the social policy title. Now, the choice of the instrument. We first and foremost very clearly see this happening as a directive, and this is because soft law instruments have not been sufficient. There is a normative argument that is very clear. There are rights, there's a right to social protection, a right to social assistance, and rights, in order to be rights, need to be justiciable, meaning that they need to be enforceable before a court. And this is only possible at the EU level in the form of a binding instrument. As such, if we want to entitle citizens to have legal claims, we need to do this through a directive. This would also allow, moreover, the Commission to overview the performance of member states, and where there is an infringement, perhaps launch infringement procedure. Now, this is, of course, an ideal scenario, and we know that politically this is perhaps a lot more, or perhaps surely a lot more complicated than it is from a legal point of view. So we also envision what a recommendation could look like. And this comes now very handy because, as I said before, the action plan is planning to put forward a recommendation, not a directive. As such, the main difference between the directive and the recommendation would be that a recommendation is not enforceable, but the content would remain pretty much the same. What is important to remark here is that if we go for a recommendation, if this is the only politically feasible solution, this needs to be different from the previous recommendations that we were talking about. And we think that the way of making this difference is by installing a robust monitoring system. This is not new to the European Union. In fact, it's something that is increasingly happening. It was installed for the recommendation on access to social protection, and it is now also envisioned for the proposal on minimum wages. And while it is not a binding instrument, it does put an obligation on member states to report on their progress vis-a-vis the minimum income, the core standards, the recommendation would set. And as such, it would give the recommendation a platform for discussion and review. Excuse me. Now, regarding what the directive would have as a content, it's very much reflective of the problems that Anne was talking about in the beginning. As such, we would think that the main core of the directive could be divided in 3 pillars. Please, if you can't hear me, let me know and I will stop talking, because I have problems hearing myself at this moment. So, please interrupt me if it's not clear. So as I was saying, there's a core content that we would distribute in 3 pillars: adequacy, accessibility, and enabling minimum income. As regards adequacy, this could mean that minimum income schemes need to be defined, clearly defined in a way that are sufficient to live a life in dignity. Now, a life in dignity is not something that is clearly defined, and for that we would use methodologies such as the a 60% medium income threshold that could moreover be underpinned by using preferably cross-national comparable reference budgets to make sure that this percentage actually is reflective of the country situation. Minimum income schemes could have to be accessible, which means that first of all, the personal scope could be targeted to EU citizens and third country nationals with legal residence, which is also the personal scope of the European Pillar of Social Rights. The minimum income would have to be accessible insofar as the assistance is needed and as long as it is needed. It could have to be non-discriminatory and put forward in a non-stigmatizing way. And we would have to limit the excessive or unreasonable conditionality criteria and make this as transparent as possible, so it is not a burden for citizens to claim their rights. And lastly, it would have to be enabling, meaning that the minimum income directive would have to boost empowerment and market participation in a way that it prevents any inactivity traps and provides incentives to take up work for those who are able, of course, to work. Other provisions are probably for lawyers very well known. Would include an aim and objective definition, a very clear material and personal scope, reference to fundamental rights and to the objectives of on the treaties, a number of information and transparency requirements, a non-discrimination provision, the monitoring and evaluation provision, provisions on financial support and access to EU fundings, a non-regression clause, enforcement and remedy, and transposition. The latter two, of course, in the case of it will be a directive. This could not be necessary in the case of a recommendation. Now, this brings me to the last point, to the conclusions. I won't repeat this very deeply, but there are a number of reasons for the EU to engage in minimum income, whether we look at human rights, public support, to balance the social and economic pillars in the Union, to reduce inequalities between the member states. So there are reasons to adopt this minimum income. And we see, on the other hand, that whatever has been done until this point, it's not sufficient. And this is why we argue that we need a legally binding instrument. For this reason, we suggest to adopt the Framework Directive, which is based on Article 153 on integration of people excluded from the labor market, and Article 175 on social cohesion, because we see this as the competences to better address the fight against poverty and social exclusion at the EU level. Last but not least, this minimum income is very important to fight poverty and social exclusion, but alone it will not be sufficient. And as such, it is essential that this is combined with different approaches, such as access to minimum wages and sufficient minimum wages. This is also in reference to what Anne was saying before, and that the ceiling that it creates and the hierarchy that is necessary, and also access to social protection for all. This is it on our side, but we look forward to the questions and answers. Just a small reference to the expert study, which can be found in the EAPN website. That's the link. And if you have any questions after this session, you can always reach out to us through our emails. Thank you very much.